Hello everyone, this is KOMAL, MATHUR, a legal intern at LEXIS and Company and a law student at Manipal University, Jaipur. I'm glad to have this opportunity to intern with LEXIS and Company, which has given me this chance to present in front of you all. So the topic or purpose of today's video is to discuss about the doctrine of Eclipse. So let us first start about knowing the doctrine of Eclipse, what it is and how does it works. So the doctrine of Eclipse is a doctrinal principle that promotes the idea of prospective fundamental rights. If the legislature passes a law that is incompatible with the fundamental rights as mentioned in Part 3 of the Constitution, such law is declared illegal and inoperative to the degree that it is eclipsed by the fundamental rights. The applicable fundamental rights obscures the laws and the eclipse is said to be thrown on it. Only by amending the related fundamental right can the inconsistency of that particular eclipse law be removed. After that, the shadowing is lifted and the law becomes legal and functional and operative once again. In other words, if I explain, a law that violates the fundamental rights becomes dormant. It becomes inoperative, unenforceable and takes the form of a sleeping arrangement. It isn't a nullity or void from the start. Now let us talk about evolution of the doctrine of eclipse. There were three stages to the development of this particular doctrine, which is the first step was the Article 13(1)'s prospective or retrospective nature, as discussed in Keshwanand, Madhav, Menon versus State of Mumbai. So, in the reaction of the case of Keshavan, various difficult problems surrounding the doctrine have been raised, including the retrospective and prospective nature of the Article 13 Clause 1. As well as the interpretation of the word void in the Article 13(1), the petitioner was prosecuted under the Indian Press Emergency Powers Act of 1931 for publishing a pamphlet without authorization in the landmark case of Keshavan Madhav Menon versus State of Mumbai. So when India's constitution was being drafted, the case was still pending. The fundamental question was whether Act's provisions violated the Article 19(1) Clause A. Then the relevant regulations were found to be in violation of Article 19 Clause 1 Subclause A and held void to the extent of their inconsistency according to the court. The court held on to say that fundamental rights are presumptively prospective in nature and the term void did not imply to the statute or provision had been repealed. Now the second step was in the FN Balsara and Bhairam Khushit Pesikaka versus State of Mumbai case, which was one of the first cases to explain the reasonable connection between Article 13 Clause 1 and pre-constitutional regulations. The appellant was accused of violating Section 66 Clause B of Bombay Prohibition Act of 1949 in this case. Previously, in the case of FN Balsara, Section 13 Clause B of the same act was held void for violating Article 19 Clause 1. As a model, the appellant used the case of FN Balsara, Section 66B, and then held inoperative and unenforceable. The court ruled that only a portion of the law was unconstitutional and not the entire law. Furthermore, the accused bears the burden of proving citizenship and the provision's violence. The third step was in the case of Bikaji Narayan on the origins and evolutions of the Eclipse doctrine. In the case of Bikaji Narayan, the Kras versus State of Madhya Pradesh, the doctrine's concept, principle and the applicability were refined. The CP and the Berar Motor Vehicle Act's amendment, which authorized the state government to control and take over all the motor transportation enterprises, was challenged in this case because it violated Part 3's Article 19(1) Subclause G. The doctrine of eclipse applied since this amendment act was pre-constitutional law and the provisions of this legislative act were rendered inoperative. Soon after, in 1951, the first constitutional amendment act was passed, overturning the eclipse and making the law effective against both citizens and non-citizens. The impact of the modification was to remove the shade and to make the impugned act free of every blemish and infirmity. The Supreme Court said it will be enforceable against non-citizens and citizens according to the court. Now, let us discuss about some features of this doctrine of eclipse and its significance. The following are the doctrine's most important features and characteristics. The first is pre-constitutional laws applicability. The doctrine only applies to the pre-constitutional laws that became active after the Indian Constitution was adopted in January 26 and 1950. Second was post-constitutional laws are not applicable. They can't apply to post-constitutional legislation because they are unconstitutional from the start and can't be changed afterwards. Non-citizens, on the other hand, cannot take advantage of voidness because they are not affected by the breach. Third provision was violation of fundamental rights. Only if the previous law is alleged to be infringing on the fundamental right may it be dismissed as inoperative. Fourth feature was inoperative. The doctrine is founded on the notion that a law that violates the fundamental rights does not become null or void at the outset, but rather becomes faulty and unenforceable over time. The fundamental right that the law violates overshadows and obscures the law. As a result, the law is not dead but is dozing off. So last and most important the feature of this particular doctrine was amendment to the fundamental rights. If the applicable fundamental right is amended in future, the challenged law will become effective automatically without any kind of notification. So that's it for today. Thank you everyone. Have a nice day.